Let us discuss today a very important subject, a very easy and interesting subject, and that is the subject of international law. So when we say international law, so there are two words, international and law. International, that is many nations, inter, between, among nations. As there are around 200 nations in the world, or 200 states in the world, because state is more geographical entity, while nation, that is more related to the people. So international, that is not between persons, that is not between individuals, but that is states. State is the unit, nation is the unit. And law, law is the set of regulations, rules, principles which are made by an authority or legislature and which are implemented to regulate behavior of individuals, or in this case states. Why laws are made? That are made for the benefit of society, for the benefit of individuals, and if somebody does not comply with law, so there is punishment, there is sentence, there is penalty. That is called law. So one is legally bound to obey laws. So some people call it so-called international law. Even they challenge the name that there is no international law. Because if this international law cannot be enforced, because each state is sovereign. For example, each individual is immune. Each individual is safe. I say, for example, I don't obey any law. I am beyond, I am above law. So what will be the utility of that law? So there is a paradox. Paradox means self-contradiction. If the state is sovereign, if the state is independent, and the state does not obey law, so where is international law? So this is why international law is called soft law. It is not hard law. Soft law means that its implementation, its promulgation, that is not as secure, as sure as law, like the general law, civil law, criminal law, the laws which are made by national legislature or by judiciary, because law can be made by an authority, by legislature, or for example the precedents of judiciary, of judges, also become law. So international law is very interesting, and in today's globalized village, because of globalization, because of internationalization, because of the global impact of internet communication technology, the whole world is becoming closer. So we need a law. For example, there was a time that the individual living in a jungle, in a like a we would call it jungle law. So that individual was not subservient. That individual was not obedient. I don't believe in law. I will not comply. Nobody can enforce law on me. So from the jungle time, the human civilization developed, and then we made laws, and there was a king in authority, and later on legislature, because of democracy, would make laws, and those laws would regulate behavior of the citizens. So people at the beginning, they were resistant to even municipal laws, or they were resistant to criminal laws. Criminology, that is a subject which studies this whole development. So now each state has the same rigid behavior, that why I am sovereign, I am independent. Why another state or another organization will implement, will enforce its laws on me? No, I am immune. My defense is strong. I won't prostrate, I won't comply, I won't obey laws which come from above. For example, at your home, you don't recognize the jurisdiction of another home, another house. Your neighbor can't come and your neighbor can't tell you that you do this thing at your home. Your behavior is not regulated by your neighbor inside your house. So, similarly, one state does not listen to another state. So this is a paradox. This is a self-contradiction. It is not even law because law must be enforced. And if for the enforcement of law, there are enforcement agencies, law enforcement agencies like police, maybe in some cases army, rangers, militias, different kind of constabularies are made to implement, to promulgate, to enforce law. So where is that police which will enforce international law? Although we have Interpol, international police, but how much is the power in the hands of international police? But it doesn't mean that international law does not exist. It exists, and it is very important for international relations because today, in today's globalized world, we need a set of regulations in the form of international law, that if there are conflicts, if there are problems between states, so what should be the mechanism? And that mechanism is international law. Right from the time of the Treaty of Westphalia, the nations are behaving like entities, and one nation must have relationship, political, commercial, cultural relationship with other countries. That's why we have diplomacy, we have international relations, and we now have to codify the rules and regulations of this relationship, this international relationship, and those rules we call it international law. Now, what are the practical examples of international law? United Nations, like General Assembly or Security Council, especially General Assembly is a kind of international legislature, although they only pass resolutions. They don't pass or they don't legislate, they don't make laws to be implemented in the world. But a time is coming that when international law will become a reality, like municipal law, like criminal law, like national law that we have in our countries, in our states. What are the sources of international law? International law, like for example, the sources of other laws is legislature, and when the parliament make the law, so that is implemented. So where from international law come? International law basically come from treaties, and this is why it is called international public law. Treaties, agreements, protocols, memorandum of understanding, these are signed between states. Then customs, customary international law. There are customs, for example, diplomacy, war, and for example, consular jurisdiction. For example, a diplomat goes from one country to another court, the privileges, the immunities. All these are customs. And then there are recognized norms, recognized principles internationally in the world. And there are some secondary sources of international law, like some scholars, when they write on a subject. So if the writing is effective, then it becomes a source of international law. Similarly, like for example, some important decisions taken by courts, especially international courts, like International Criminal Court or International Court of Justice or European Court of Human Rights. There are so many, and another branch of international law, that is supranational international law. Supranational is that when the one nation, one country say that, okay, I will leave, I will abandon my this jurisdiction and this particular law, and some international organization can intervene. So then that is called supranational. And there is also private international law. In the private international law, that is the law of conflicts. For example, one individual from one state and another individual from another state, there is a conflict. There is a conflict of trade. Like nowadays, there is a lot of international investment from one company, from one individual in another country. Now, that person is not the citizen of that particular country. The person comes from one country, she or he invests in another country, and then there is a conflict. So what should be the reconciliation? What should be the arbitration? How that conflict will be resolved? So the way it is resolved, that is by private international law. And this is the conflict, and then they have some arbitration or any kind of legal framework which can resolve the issue, because the person who is in his own state will say that, no, I am the citizen of this particular country, you coming from another country cannot impose your legal system on me. And he or she will say that, why I should obey your laws, why shouldn't you, you should not obey my laws, the laws of my country. Like, for example, a person from United States or Canada goes to Pakistan, so which law will be they will obey if there is a conflict, if there is a problem, if there is a legal problem, or there is a some dispute, for example, maybe an investment or maybe some trade issue. So in that case, international law, it comes. Now, for example, criminal cases, one person commits war crimes, or the weapons of mass destruction, or nuclear weapons. So where should be the trial? If that trial is done in his or her own country, so then that country may have another kind of system. That person may be the president or the commander in chief of the army. So how that country will punish that person, or how that person will be taken to the court of national courts. There must be a system, and that's why we have this international law, and we have international court of justice or international criminal court. So, and there is, for example, human rights issues. Human rights, for example, one person has problem in his or her own country, so that person can become refugee in another country, or may seek asylum in another country. So all such things, we need an international law. Otherwise, there will be vacuum, there will be no way how to resolve such issues. Similarly, for example, humanitarian crisis, there is genocide. One country, the rulers, they are trying to destroy, they try to wipe out, root out a particular community. So what the international community should do at that humanitarian situation? There should be some way to intervene in that situation. So basically, international law is necessary. That is very important, although so far it has not got the status as the national laws, for example, in a particular state. Because as I earlier said, that each individual has some resistance to the law. So similarly, states are now resisting international law, that our own sovereignty, because one country cannot implement. United States, for example, is more developed, is more advanced, or Canada, they have better standards of human rights, and they want that the other country should also have the same standards. But that country, there may be dictatorship, there may be military government, there may be monarchy, there may be one ruler, that dictator is governing the whole country. So how the democratic values can be implemented in that particular case? Similarly, we have international sea law. That is also very important, because water is something which is fluid. The water goes from one country in the shape of ocean, rivers, sea. So there must be a law that where are the boundaries, which country boundary starts where, because geography, land, that is quite like visible. We can say where is the boundary, where is the frontier, where is the boundary line. But sometimes in the sea we have problems. Similarly, fishing, that one country is doing fishing or exploring natural resources, oil or other. So the water is very fluid. Some person is exploring diamonds in the water, or maybe in other pearls or precious stones. So when that person will go and will touch the jurisdiction of another country, so what will be the situation, and if there is a conflict, so how we can resolve this situation. So for that, then we need international law. So the history of international law is also quite interesting, that how it became an important discipline, because at the beginning there was a lot of resistance to international law, but with the passage of time, now international law is becoming reality. International law is a tool in the hands of idealists, and United Nations itself is, the utopia, the idealist world, where human rights, development, and such aspects of life are explored, and these are given practical shape in the states. Sometimes the position of state to international standards, international principles, it becomes a big obstacle. So if international law, international customary law, or treaties or agreements, sometimes they say that treaties are there if it is law, if it is lost, if it is preserved. If, for example, a state signs an agreement and tomorrow there is a war and everything is fair in love and war, so what will happen to international law? So there must be these customs, these internationally recognized principles must be codified. And international court of law, justice, or international criminal court is some of the examples. Some of their decisions are now becoming like decisions taken by other courts, becoming precedents, and the people quote such decisions even in national courts. For example, some of the decision of international court can be quoted as a precedent. So it gives more respect to international legal system. So simply, we need as individuals some rules and regulations, then as community and society we have some norms, and we have some values. So similarly, a state, we have different laws made by our legislation. So each state, if even there are 200 states, but these 200 states are very important, and they must have good relationship with other states. So how these international relations may be regulated? So when it comes to the regulation enforcement, then we need law. If there is no law, there are no set rules. So how we can the relationship between or amongst the nations will be meaningful. So for the meaningful relationship on international, global level and regional level, we need, for example, European Union without international law will not have that important position as it has, like SAARC, ASEAN, other international organizations, not only United Nations. They need international law. So the sources of law usually, that is like, for example, customs and principles and rules. Religion, except a Muslim country, is not that much important source of law, but other secular sources of law are getting more importance in the world. And a day is not far that when international law will become a real law, and then the people will not call it so-called international law, because it has no enforcement. So the people, they are challenging its reality. There is a lot of criticism that we don't need international law, but because of the globalization, we need international law so that states also become responsible. It's a big challenge to the world today that one state may not intervene in the affairs of another state, the other state should also have some legal status, some legal background, and some legal force to defend itself, and to take that other state to international court where both the states will become parties. And there are parties. For example, recently Pakistan and India, whenever we have disputes, territorial disputes, or other disputes, water and other distribution. So for example, rivers come from up down. So how from one country the river starts and it goes to another country, or a sea and ocean, as I already mentioned, the law of sea, that is so much important. So international law is very interesting subject. I will recommend it, that you must read it if you have legal background or not. But if you have some interest in international relations, so the codified or the legal aspect of international relations, that is international law. This is my first introductory lecture. We will continue the series of lectures on international law. I hope you found it useful, and we can discuss it other aspects in international law, group of international law. Thank you very much.